time has passed since the original data collection for this project. In between then, I actually have moved back to Australia from the US and have been doing other things. And so this for me is a little bit of a revisit on this project since I had a paper published last year. And I'm really excited to continue to do this research, especially now that I'm back in Australia. But the research that I'm going to be talking about today is from a family treatment court, a drug court, from Washington State. At the time, it was the first one in Washington State, and it was very much a trial. There had not been a lot of these types of alternative courts, specialised courts, drug courts, whatever array of terminology you'd like to use, in Washington, and it was very exciting to be able to see how this court kind of came to be and then how it progressed over time. So, as most of you already know, in the US context, there's been so many types of problem-centred courts that have kind of proliferated through lots of areas in the US, whether that's in mental health, drugs, domestic violence. Dependency cases is another one where you've seen a lot of drug courts start to be used. So for those of you who aren't familiar with the term dependency, we're talking about parents who have child welfare cases that have been brought against them. Their children may have been taken away from them, but they have to prove to a court that they are able to take care of their children. The other thing that we know about problem-centred courts, particularly the family drug courts like this one, is that they have been very successful, not only in curbing reoffending rates, but also in reunifying families. Okay, so overwhelmingly, there's been a lot of success around using this type of orientation to justice, particularly in the area of reunifying families, but also in others as well. The issue, though, and this became evident as I spent more and more time in this particular courtroom, that the ideas and the goals and the norms and the practices of therapeutic jurisprudence, or restorative justice, which is another term that was being used in relation to these courts back then, has to coexist with the norms and expectations of a traditional justice system, which is actually quite different, whether it's theory or in practice. Okay, so those were the main issues that were coming up when I was looking at this particular court. These therapeutic goals, or these restorative goals, have to coexist within a criminal justice system that is orientated differently. So there were two kind of general research questions that I started out with. The first one is, how do problem-centred courts function under the umbrella of traditional criminal justice? So how do they cope when they're embedded in this broader criminal justice context? And what elements of the traditional system undermine those therapeutic principles that have been in place? Okay, so we know that it's been very successful, but are there parts of the traditional justice system that are actually making it very, very difficult to make this sustainable, to pick up on the term that was used earlier? All right, so I developed this. Actually, I borrowed this kind of framework from Aaron Kupchik's work. I should mention that I come from a background of criminology, so my approach to this project is a little bit different than perhaps a legal scholar might take. But I adopted Aaron Kupchik's framework, distinguishing between therapeutic and traditional courtrooms, to really help me tease out what elements in the courtroom that I was in kind of follow this these therapeutic principles, and which ones follow the traditional principles. So for example, there were kind of three main things that were a point of difference. First, therapeutic courtrooms tend to be quite informal in terms of their interaction between the client and the judge. It's more colloquial in the language. It's non-adversarial. And the judge takes much more of an active role in the decision-making process and in the discussions around each particular case. In contrast, in the traditional courtroom, a judge interacts with the client mostly via their attorney. And on top of that, the legal language tends to dominate, which of course is something that alienates the actual offender or the client from the process. The other main difference is the court hears the legal matters only. And this is also something you see in kind of the traditional dependency court. as opposed to the family drug court. They tend to deal with those legal matters, not necessarily all the different issues that a particular family or parent might be trying to combat while they're trying to reunify their family. And of course, it's based on those adversarial principles that are so common in our regular Western justice system. The second point of difference is the way in which those decision-making processes are based. In therapeutic courtrooms, offender-based decision-making dominates. So those individual circumstances of each client, each family, each child, each parent tend to be part of that decision-making process. It's also very flexible. So if there's a problem that's indicative to a particular family, then the court is more likely to be able to, or should be more able to, help that parent navigate their particular situation. On the other hand, in traditional courtrooms, you have a decision-making criteria based on the offence type, or how serious the offence is. And usually the problem solving is guided by legal procedure, precedent, or guidelines, rather than something that's more indicative of the individual or the family. Okay? And lastly, the difference between their orientation to punishment. So punishment or dealing with those particular problematic behaviours. So in therapeutic courtrooms, it's very much based on the idea of rehabilitation. So when you see therapeutic courtrooms in action, they're trying to have an educational or therapeutic response to behaviour. And the primary goal is in this courtroom is sobriety, because it's a drug court, but also the reunification of the family. All right? In traditional courtrooms, we still see that it's very punitive. The punishment is for a violation of some kind of legal norm, and crime control is usually the primary goal. If you're thinking about Simon Thiele's work, this is exactly what they're talking about in terms of the goals of that traditional courtroom. So the Family Treatment Court in Washington State was very, very interesting, of course, because it was one of the it was the first in the state, and it was one of the first in the USA. Now, these were parents with dependency cases, so ongoing child welfare concerns and issues, and had also a co-occurring drug or alcohol addiction issue, so they had to have both of those things in order to qualify for this court program. The court had been operating only 12 months prior to the beginning of my study, which I actually think that wasn't planned, by the way, but it was something I thought was beneficial, so that I could kind of see how the court was actually working kind of 12 months in once they'd gotten their I guess the newness of the system well and underway and all those knots sorted out. Each parent is expected to spend 18 months in the Family Treatment Court program. Okay, so it's an 18-month program from beginning to end. And in that 18-month period, there's these scaffolded goals and requirements that move the parent to each level throughout the program. One thing that it is important to point out here is that parents do have to volunteer for this program. So there is some kind of selection bias going on here. And in Washington State at the time, pretty much all of the drug courts worked this way. Okay? So parents did volunteer, they can be referred, but it is their choice whether or not they want to get into this program. One of the things that makes this program distinctive from the regular dependency system, though, is the fact that they have to be in court every 2 weeks, especially at the beginning of that 18-month period. Okay? It's comprised of these review hearings, these wraparound meetings, which can include all of the members of the courtroom, including the judge, but don't actually take place in court. They're a lot more informal. They must have some form of outpatient or inpatient treatment, and they must do parenting classes. So parents going into this court know that these are the requirements of being part of this particular courtroom. In order to graduate from the FTC court, 6 months consecutive clean time. The children have to have actually moved home for a 6-month period. So you can see that's very interesting in the sense that they can still follow the parent even once reunification has occurred. So there's that continuation of care, even though that initial goal of family reunification has been accomplished. They must be successfully discharged from a substance abuse program that's tailored to their particular needs. They also are required to have consistent attendance in something like Alcoholics Anonymous or NA or something along those lines that's approved by the court. They must be in suitable housing. They have to have kind of all of their outstanding warrants and legal issues absolutely resolved. And they must have an approved support system in place. Okay, so they must have people that they can call on, that this has been discussed with the family treatment court team, and the treatment court would have to know that these people are in place in order for someone to call on once supervision under FTC has been completed. All right, this looks very neat in my head and probably very complicated for everybody else, so I apologise. Okay, so this is your typical difference between a traditional dependency court case and the family treatment court case. In traditional court, when your case begins, petitions filed, you have an initial adjudication hearing. The case is closed if there's nothing else that needs to be done, and the judge decides that there isn't a dependency case that needs to be followed for an 18-month period. At the adjudication hearing, if there is the need to follow up on the case, it will go directly to traditional dependency court. There'll be a permanency planning hearing. This is a planning for when the child could potentially be moved back home, or when the case could potentially stop being supervised. And the review hearing, this is the important part, is only every 6 months. Now, there is the option for there to be resources, but it's usually on kind of the parent's own asking for those resources that they get it. Okay, so there's nothing automatic. They're not going to automatically get resources to help them get suitable housing. They're not automatically going to get resources to get them into an appropriate drug treatment program. All right, so at the adjudication hearing, there also might be an option for those parents who have drug and alcohol addiction issues to be referred to the family treatment court program. And as you can see, it's already a lot more complicated, and there's more things on here that I actually left off. There's an acceptance staffing and acceptance hearing. What this means is the acceptance staffing is where just the treatment team members discuss the case and decide whether or not it's going to be a good fit for the court. An acceptance hearing is the first time that a parent, family, child would actually be in court in order to hear what that they're being accepted into this court program. After that, they'll have a case staffing, which is actually incredibly fascinating as someone who is an observer. This happens every week before court, where just the treatment team members, no clients, no parents, no children, get together and they discuss the cases, the problems, the good things, what needs to be done next before every single court hearing. Okay, it's very informal. The judge is involved, but it's not in kind of that same legal, formal legal setting. And then usually every 2 weeks, and of course it's scaffolded as they make progress through the court, they'll have this review hearing, and this process will rotate through that 18-month period. At the end of that 18-month period, they can either have their supervision terminated through what they have a very formal graduation process. It could be terminated by family treatment court for other reasons, and that would mean it would get kicked back to the traditional dependency court, where at that point, again, they're not going to have the support and resources that they get through the family treatment court program. All right, so I did observations and interviews with all the courtroom personnel and was in this court observing for an 18-month period. The reason I wanted to do the 18-month period is so I could at least see some cases through from start to finish. I would have stayed longer, it was absolutely fascinating, but you can't just stay forever, unfortunately. I observed open and closed court sessions, as well as all the staffing sessions, and also what they refer to as wraparound sessions, which were, again, all the members of the treatment team meeting with the parents and the children informally outside of court in order to discuss what their needs were. I did semi-structured interviews with the courtroom work group. As you can see, I only had an N of 6. That was pretty much the entire population of the courtroom work group. As I progressed, and you'll see that this becomes a problem for this court, there were more and more people, and they were less willing to talk to me, and as they were not familiar with kind of the court procedure, but I'm going to talk about that specifically in a moment. What I was really interested in from a sociological and criminological perspective was really what these interactions were like between courtroom personnel and clients. And the reason that is that we know from a lot of criminological research is that the way in which people experience justice matters for their outcomes. It matters whether or not they're going to re-offend. It matters for whether or not they're going to be able to have a reunified family that won't end them back up in the dependency system months later on. All of the interview transcripts and observation notes were coded thematically, and all the examples that I have both in the paper and in the presentation today, unless otherwise noted, represent kind of the typical courtroom outcomes that you would expect to see in this court. Now, first of all, I want to establish that there were things going on in this courtroom that were very much in line with those therapeutic principles. So this is first excerpt right here. We've got the father's attorney. Father's attorney says he's asking for visitation with his child's name. The child's attorney says, I don't object unless there are other concerns. The social worker says, I think it's too early. We've not had this parent here in the family treatment court program for very long. I feel there are too many unknowns. So the social worker's unsure about this type of contact at this point. The father's attorney says, I agree, he's not ready, especially since he's still not committed to the program. We can't get him to UA on a regular basis. UA, that's a urine drug test. So you can see here that instead of being adversarial, we've got a courtroom work group that's discussing the issues. And you can actually see the father's attorney, which as you might expect might be wanting to get the father what he wants, is actually saying, no, I don't think that he's actually ready yet, let's wait a little bit. So it's a very teamwork-based approach. Over here I've got a quote from a social worker. Being flexible in each case is also important. Each client has a different list of needs and we need to be able to accommodate that. Targeting the addiction is only part of what the FTC is about. This does not happen as much in dependency court. Cases are processed according to what the legislation states. Review hearings every 6 months, UAs every week or whatever. In FTC, each client's individual needs are addressed as they arise. So the social worker is actually making that distinction between what family treatment court does, treating those individual needs as they arise, as opposed to the kind of more clinical legal process in the traditional dependency court. Now, the first thing that I talk about in terms of the threats to this therapeutic jurisprudence process is this increasing formality. So over the 18-month period, I see that the interactions become more and more formal as time goes on. So in this first one, the judge says, you're not engaging in treatment. Did you drive today? She wasn't supposed to be driving, she lost her license. The attorney, the mother's attorney, says to the client, don't answer that. And then to the judge says, I can't allow my client to answer that, Your Honour. And then you see the prosecutor react, and it was a very emotional reaction. Excuse me, Your Honour, this is family treatment court and we need this information to make decisions about the case. Okay, so very clearly here, you've got a brand new attorney who's not familiar with the norms and interactions of family treatment court and is bringing in those outside norms, that legalistic language, that adversarial process into family treatment court. And as you can see here, that was not responded to very, very well. One of the things that you see over that 18-month period, which I argue is part of the reason why we see increasing formality, is because it's very difficult to get people staying in that courtroom work group. They tend to come in, they stay for a period of time and go out. And then towards the end, where you've got more and more clients coming into this courtroom, into this program, you see more and more attorneys that have not had any training in this particular court model, have no experience in this court model, and they expect it to be just like it would be in a traditional courtroom situation. Over here, we also have the program manager who takes care of the day-to-day running of the court. She says things have gotten very tense, especially between court management and the particular mental health organisation that was working with this court. This court is supposed to be non-adversarial, but they are acting in a way that puts everyone on the defensive. It comes down to money. We have clients with mental health needs that the organisation are not equipped to deal with, but they insist we go through them. It means that clients are not getting the services they need, and the attorneys are automatically more defensive of their clients. One of the things you also see over the 18-month period is the fact that more and more clients are coming into this courtroom. It was initially capped at 36 families. That was supposed to be the maximum. By the end, they had probably closer to double that, 60, possibly 80. I can't actually remember off the top of my head. What you see over that time period is also the organisations that are working with Family Treatment Court to provide services are not able to deal with the various different issues that each individual client brings to the table. So there's another tension that comes in where the Family Treatment Court program manager doesn't even feel they can go to other organisations to meet those needs. So it becomes much more difficult, and that process for getting people through the courtroom becomes much more formal because that tension is in place. The second threat to the therapeutic principles in this courtroom is the limited offender-based processing. So again, over the 18-month period, you see a limited ability to be able to treat each client on a case-by-case basis. This first quote is from a social worker who says, many of our clients have medical issues and need to be on prescription medication, and the court and judge have tried to be sympathetic to those needs, but without clear guidelines, it can become confusing. I would like to see some strict guidelines about behaviour on that issue rather than taking each situation on a case-by-case basis. So again, even though that's what they were originally kind of planned to do with this court, is to be able to address those individual needs, as more and more clients come into it and they're seeing these problems come up again and again, you see the attitudes shift away from wanting to treat people on a case-by-case basis to wanting to have strict guidelines that actually direct exactly what needs to be done in particular situations. In this other excerpt from a review hearing, we have a judge that says, you went over this acceptance order with your attorney, correct? Judge holds up a piece of paper that the client signs. The client says, yes, Your Honour. The judge says, just wanted to make sure, that was sarcasm, the treatment staff and your social worker have some concerns about whether or not you're in treatment. Have you been in this program? You have been in this program for a month now. In this acceptance contract, you agreed that you would be in an inpatient or outpatient treatment program as directed by the court. Are you in one? The client says, not at this time. I can't seem to get into a program when I have to work full time. The judge says, what were you thinking committing to this program? You have to complete a treatment program to continue to be in FTC. What's interesting about this, at the beginning when I first started observations, the court absolutely went through every measure to be able to find outpatient or inpatient treatment programs that helped clients retain any legitimate work that they had. And that was something that was really important. But with so many clients who are having this issue, the court is unable to be able to do that one-on-one problem solving. So this is something that tends to have fallen to the wayside as the court tends to increase its caseloads as time progresses. And then lastly, the last therapeutic jurisprudence principles in this courtroom is the increased punitive attitudes, which I actually thought was quite fascinating because when I began in this courtroom, it was very heavily, all of the attitudes were about rehabilitation is the most important thing. We must be able to reunify the family through rehabilitation so that those parents don't end up back in dependency court 6 months later, a year later, 18 months later. In this first one, the judge says, tell me what the cocaine is about. The client says, I'm being accused of something I've not done. She's yelling and crying, very emotional. The judge says to the treatment team that if the client cannot produce a clean UA in 30 days, she'll be put in jail as a consequence. The judge says to the client, you must UA twice a week and attend court every week, even if your case is not scheduled. She has to be in court even though her case may not come up. Otherwise, I will put you out of the program. The prosecutor says, this client committed fraud against the court. I believe she should go to jail now or today. So you can see here that there's a bit of conflict. She's got cocaine in her last drug test. She's not copping to it. But the automatic response here is straight to jail or being put out of the program. At the beginning of this 18-month period, lots of people were in this situation. Lots of people were not honest about their drug use. But that never would have, these two consequences never would have come up. You can see it also in terms of the social workers' attitudes. We need more meaningful sanctions. We need to make use of jail time. There are some cases when it's really necessary, and even when I think they've done something pretty bad, no sanction is given. So the attitudes themselves of the people who have been, this is a social worker who's been in the courtroom since the beginning, you can see that their attitudes around punishment has shifted away from rehabilitation to something that's much more punitive.